In New South Wales, child sex claims are normally referred to the Joint Investigation Response Team, or JIRT, if the complainant is a child, or they're investigated by police if the complainant is now an adult. In New South Wales, charges can be brought if police have a suspicion on reasonable grounds of an offence occurring. And this can be an uncorroborated complaint, or even a complaint about something that allegedly occurred many decades ago. So in New South Wales, police can arrest a person, charge them, and refuse bail on the basis of an unsupported or uncorroborated complaint. The defence lawyers will then have to apply, if bail is refused at the police station, to get the client out of custody on bail. Police will normally only then thoroughly investigate the complaint, its credibility, its consistency with surrounding circumstances, whether any supporting evidence is available. Clients will sometimes ask, how can I be charged with such a serious offence if the evidence against me is just an uncorroborated complaint? Now, the situation in New South Wales is very different to the situation in places like the USA. Now, in the USA, police must establish a probable cause before arresting a person. So they must gather a certain amount of evidence before they can arrest and charge someone. Now, our clients will have often watched television shows which may suggest that a certain amount of evidence needs to be acquired before someone is charged. However, the situation in New South Wales is essentially a shoot first and ask questions later approach. That is, all the police need is a reasonable suspicion and they can charge someone. In USA, it's an ask questions and then shoot approach because a person's liberty there is considered to be very important. We have had many cases where a person was arrested, charged and refused police bail, but it later becomes clear that the person is innocent of the charges. That is, that the person could not have been there at all, or the complainant's statements are significantly undermined by other material, such as subpoenaed material or by other witness statements, or where the complainant retracts their statement later on. Even in these cases, defence lawyers must still push to have cases dropped, because the prosecution can be reluctant, even where there's very little evidence, to drop cases for fear of criticism by the public, by the media, by the family. However, by that time, a person's reputation may have been destroyed. So we need to push early on to get cases dropped to protect a person's liberty and their reputation. Where the evidence against you turns out to be weak or unreliable, it's vital for your lawyer to push for the early withdrawal of the case to protect your liberty, your reputation, livelihood, mental health, your finances. Where the prosecution nevertheless proceeds with the case, you should look for criminal defence lawyers with up-to-date knowledge of the many special rules that apply to child sexual assault trials. Perhaps lawyers that work as a team, that is, several senior lawyers working on your case at once. Lawyers who will thoroughly prepare for your trial by issuing subpoena, interviewing witnesses, conducting or arranging investigations, obtaining favourable evidence. Perhaps look for lawyers with a proven track record of winning sexual assault trials and protecting the liberty of their clients.